Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications. Exercise number 5 and 6 on the speed of 90 words per minute. Start. The facts arising out of the present writ petition are that on the basis of advertisement made by the respondent in the year 1989 for the purposes of appointment on the post of constable, as the petitioner was fully eligible to be considered and appointed, he submitted relevant documents, and on the basis of aforesaid document, petitioner was considered treating his date of birth as 15th November 1969. The high school certificate issued by the Board of High School and Intermediate of the year 1983 was submitted at that time. Petitioner, on the basis of aforesaid appointment, was working, and the conduct of the petitioner was always appreciated by the relevant authority from time to time. It appears that on the basis of some complaint regarding various persons who have obtained the appointment, claiming themselves to be dependent of the employees working in the department under the dying in harness rules, some investigation was made without any notice to the petitioner, and it was found, as alleged by the respondent, that in the certificate submitted by the petitioner of the high school, the date of birth of the petitioner is entered as 15/11/1965. Though in the certificate which has been submitted by the petitioner, the date of birth is recorded as 15/11/1969. The contention of the petitioner to this effect is that in case on the basis of some complaint, if the respondent was of the opinion that on the basis of some enquiry made thereunder the certificate submitted by the petitioner was having some discrepancy or wrong date of birth according to respondent is entered, the petitioner was entitled to have a show cause notice and opportunity. The appointment of the petitioner cannot be cancelled without any notice and opportunity, that too after completion of about 17 years of service in the police department. In case the petitioner would have been given a liberty, he would have submitted a certificate issued by the high school board, which was submitted at the time of entrance in service, without any notice and opportunity to the petitioner. The order impugned dated 22/2/2008 cannot be passed. The petitioner has placed reliance upon a judgment of Apex Court reported in 1991 1 SCC 330 Shravan Kumar Jha and others versus State of Bihar and others. On the strength of the aforesaid decision, learned counsel for the petitioner submits that in case on the basis of some enquiry it was found by the respondents that certificate submitted by the petitioner is not correct, or they have come to the conclusion that it is a forged certificate, the principle of natural justice has to be observed and no order can be passed without any opportunity to the petitioner. The division bench of this court has held that termination without any show cause notice or opportunity to defend has been held to be violative to the principle of natural justice and has quashed the order of termination. On the other hand, the respondent filed a counter affidavit stating therein that in a writ petition filed by one Avnish Kumar, this court has directed that the respondent may inquire into the matter regarding the employees who have obtained the appointment under the dying in harness rules on the ground that their father or mother were in service of the respondent and died in harness, and on that basis some enquiry was conducted and it was found that the birth certificate submitted by the petitioner appears to be forged. Further allegation has been made that after inquiry it was found that only to get an appointment in the police department, the forged certificate of birth has been submitted by the petitioner. Therefore, the appointment or selection of the petitioner is hereby cancelled. I have considered the submissions made on behalf of the parties and perused the record. From the averments made by the parties in the writ petition as well as in the counter affidavit, it does not transpire that petitioner was ever given a notice and opportunity before passing the order impugned. Admittedly, the petitioner's appointment was of 1989. In case some inquiry as submitted by the respondent was made and a conclusion was arrived upon that petitioner only to get an appointment has filed a forged certificate claiming that his date of birth is 15/11/1969. Petitioner's case is that he has passed the high school in the year 1983 and certificate issued by the board was submitted mentioning therein that the date of birth of the petitioner is 15th November 1969. The respondents have not disclosed the fact that from where they have inquired into the matter and what are the documents to show they are under that the certificate submitted by the petitioner was forged. Therefore, in my opinion, it was incumbent on the part of the respondents to have a proceeding against the petitioner as provided under the rules. The regulation itself provides that in case of some misconduct or if on the basis of some inquiry it has been found that a person has obtained the appointment by playing fraud, in that circumstance, unless and until the procedure of inquiry as provided under the rules is followed, no disciplinary action can be taken against an employee. It is also not the case of the respondent that after verification from the petitioner also it was established that the appointment has been obtained by playing fraud. Therefore, in view of settled principle of law, it was not necessary to give a notice and opportunity and to have a disciplinary proceeding against the petitioner, as it is settled in law that fraud vitiates everything unless and until it is established the procedure as provided cannot be bypassed. Article 3112 of the Constitution of India provides for dispensation of inquiry in case a finding is recorded by the disciplinary authority that it is not possible and feasible to have an inquiry in the circumstances of the case.